So there you have it. The Supreme Court just fired another shot across the bow when it comes to these assault weapon bans, and the legal landscape is shifting fast. DOJ and the ATF may keep pushing, but this 6-3 decision signals where the High Court is leaning. And state-level bans are starting to crack under the pressure. The Second Amendment fight isn't over, not by a long shot, but the ground is moving in favor of gun owners. I want to hear your thoughts. Would you support this kind of federal override to shut down state-level assault weapon bans for good? Drop your take down in the comments. And as always, hit that like button, share this out to your range buddies, subscribe for more no BS gun talk, and smash that bell icon so you stay ahead of every major Second Amendment update as it breaks. Stay sharp, stay safe, and, as always, lock and load. The 6-3 ruling explained. The Supreme Court just delivered another 6-3 decision, and this one's sending shockwaves through the entire Second Amendment fight. While this ruling didn't directly strike down every assault weapon ban on the books, it reaffirmed and strengthened the legal standard set by the landmark Bruen case. Any restriction on firearm ownership must fit within this nation's history and tradition of gun regulation. And here's where it gets serious. Most of these so-called assault weapon bans that states have passed don't have any historical roots to stand on. These bans are built around modern cosmetic features, pistol grips, adjustable stocks, detachable magazines, features that simply didn't exist when the Second Amendment was written. The Founding Fathers weren't regulating detachable box magazines or semi-automatic actions because those technologies didn't exist yet. They regulated access to arms in a way that recognized the individual right to self-defense as core to American liberty. Under Bruen's strict scrutiny standard, these kinds of modern bans face a serious uphill battle in court. The state can't just claim public safety or argue that modern firearms are somehow uniquely dangerous. They must prove that similar restrictions existed historically, back in the founding era. And the historical record doesn't support banning rifles based on features like barrel shrouds, flash hiders, or the number of rounds a magazine can hold. That's exactly why this Supreme Court decision is being seen as a major signal, not just for gun owners, but for every lower court judge now reviewing state-level bans. It's forcing courts to stop rubber-stamping gun control laws and instead apply real constitutional scrutiny grounded in America's founding legal traditions. DOJ and ATF pushback. While the Supreme Court may be signaling where this fight is heading, the DOJ and the ATF aren't exactly backing down. The Biden administration and federal agencies continue pushing aggressive regulations, not through new legislation passed by Congress, but by rewriting definitions and expanding their own authority through executive rulemaking and agency reinterpretations. We've seen this playbook time and time again. First, they moved to redefine what legally counts as a firearm under federal law, expanding the frame and receiver rule to target so-called ghost guns. Then came the reclassification of stabilizing braces, instantly turning millions of legally owned pistols into short-barreled rifles under the NFA without a single vote in Congress. And let's not forget attempts to further restrict importation rules, redefine what constitutes an NFA item, and regulate home-built firearms, all executed unilaterally by federal agencies rather than through the legislative process. Even as federal courts begin striking down these rules under Bruen, the DOJ continues filing appeals, buying time, and keeping these regulations in place as long as possible, while lawsuits slowly work their way through the system. And make no mistake, this is a calculated strategy. By keeping these cases tied up in litigation, they delay the full effect of Supreme Court decisions. It's not always about winning outright. Sometimes, it's simply about stalling enforcement long enough to discourage plaintiffs, burn through resources, and maintain the restrictions through procedural delays. Gun owners are caught in the middle of what has become a legal chess match. Federal agencies are playing procedural defense, while the High Court keeps issuing stronger signals about the constitutional limits of their power. And while the Supreme Court's rulings build momentum for Second Amendment rights, these agencies continue using every tool they can to slow the implementation, hoping to drag out the process for years. Legal domino effect. This 6-3 decision isn't just a single ruling. It's setting off a chain reaction across the lower courts. Right now, dozens of state-level assault weapon bans, magazine restrictions, and semi-auto prohibitions are tied up in federal lawsuits, and every single one of them is being reevaluated under the Bruen standard. Courts can no longer simply rubber stamp these bans by citing public safety or government interest. Instead, they have to find clear historical analogs that justify these laws, and that's where the state-level bans start to collapse. There's no historical tradition in the United States banning rifles based on cosmetic features, detachable magazines, or how many rounds a magazine holds. That puts bans in states like California, New York, New Jersey, Illinois, and others directly in the legal crosshairs. For example, California's bans are currently under fire in active cases like Miller v. Bonta and Duncan v. Bonta, both challenging magazine limits and rifle feature restrictions under the Bruen standard. Some courts have already started reversing previous rulings, while others are issuing temporary stays as they scramble to reevaluate under the Supreme Court's clear guidance. The longer this process plays out, the more pressure builds for these bans to eventually fall, not by legislative repeal, but by constitutional ruling. Tactical takeaway for gun owners. So, what does all of this mean for you as a gun owner right now? Bottom line, this fight isn't over, but the battlefield is shifting fast in our direction. The Supreme Court's 6-3 ruling reinforces Bruen as the controlling standard, forcing lower courts to apply strict historical tests instead of letting anti-gun legislation hide behind public safety arguments. That creates real momentum against state-level bans on so-called assault weapons, magazine capacities, and semi-auto rifles. But don't get complacent. The DOJ and state attorneys general are still playing defense through endless appeals and procedural delays. This is exactly where gun owners need to stay locked in. Follow these cases, support legal challenges, and stay involved at both the state and federal levels. The Second Amendment isn't self-enforcing. Court victories only hold if we keep the pressure on and hold lawmakers accountable. Right now, we're seeing cracks form in laws that some politicians swore would never be challenged. Stay sharp, stay engaged, and stay ready, because this legal fight is far from finished. So now you've seen exactly how this 6-3 ruling could start cracking open assault weapon bans nationwide. But that's just one part of the fight. We're still watching the DOJ, the ATF, and multiple state-level cases where the legal chess game is still playing out. Some states are doubling down, passing new restrictions right as the courts are pulling the rug out from under them. Others may start folding under the pressure once lower courts start applying Bruen more aggressively. But here's my question for you. Do you think we'll see a full nationwide rollback of these assault weapon bans in the next 2 to 3 years? Or will the courts keep letting some of these states drag it out indefinitely? Drop your take down in the comments. I want to hear how you see this playing out. And if you want to stay locked in as the legal fight keeps moving, hit that like button, share this out to your fellow gun owners, subscribe for more no BS Second Amendment coverage, and hit that bell icon so you never miss the next tactical update. Stay sharp, stay safe, and as always, lock and load.